This Part 8 hearing is in the matter of case number CFI 096-2022 and is being held by way of video conference before Justice Sir Jeremy Cooke, appearing from London. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by DLA Piper Middle East LLP. Lead counsel is Mr. Andrew Mackenzie. The defendants are not present. Will the judge and the parties and the claimants represented please confirm that the situation is as I have stated?
Confirmed.
Confirmed.
Now, Mr. Mackenzie, I've obviously seen the email that's come in, and I've just had a quick glance at your email to the court as well. Is it your submission that I should simply carry on and hear your application in full?
It is, Your Honour, yes. From our perspective, the defendants have had more than sufficient time to ready themselves for these proceedings, and I can take Your Honour through the various chronologies with respect to service and notification, if that would be helpful. But fundamentally, we think. Sorry.
I don't have much doubt about that. There's still the overriding questions which are raised by the email that's been sent, and whether there is truth in the questions of the liquidator and service on the liquidator and so on. Are you in a position to deal with the points that are made in subparagraphs little 1 through to little 4 on the first page of the email of the 1st of May?
We're not, Your Honour, chiefly because we've only just become aware of these. If they're the allegations or statements made by the defendants' lawyers are accurate, and we have obviously no way of testing them at this point in time. There's been no evidence provided, whether it's copies of the case judgments or applications or files. So at this point in time, I can't enlighten the court any further.
And that seems to me the fundamental difficulty. I mean, if the position is that the defendant is in liquidation, and if the position is that you've served, as you say you've served, on the chief executive officer, then there's a potential problem. And I'm bound to say, Mr. Mackenzie, my inclination is simply to adjourn this matter to give you time to deal with that. I'm fully alive to the provisions of the rules which say that without an acknowledgement of service, the defendant can't take part in any hearing. But I've got to satisfy myself that it's appropriate to make the order that you seek in terms of recognition and enforcement. And if there is an underlying problem, we need to grapple with it. So I think my question to you is simply this: how long do you think you need to ascertain whether there's any truth in what is being said in the email of the 1st of May from whoever it's from?
Al-Dahri International. Yes. I mean, so 2 points on that, Your Honour. One is we would maintain that the email that was sent with these allegations contained in, obviously, is very late in the day, but I do appreciate that Your Honour wishes to grapple with them for obvious reasons. We would note that there's a notification was given to the law firm that purported to represent the defendants in this case, and that was issued on the 17th of November 2022, so post the supposed commencement of these liquidation proceedings, if the dates by which the allegations made in the other side's email are to be trusted.
Where does the date appear in the email?
So they've said at point 3, Dar Company is under liquidation as per Court of Cassation cases 2019 and 2020. And our letter, our notice to the other side's lawyers and their reply, which is at document number 82 in the bundle, Al Markaz Law Firm, confirmed on the 17th of November 2022, so a full year after the supposed liquidation proceedings were commenced, that they represent the investment company, the defendants. There's no mention in that letter, and I appreciate we've issued Your Honour with a copy of the redacted version of that letter, but please take my word for it that there is no reference in that letter to any liquidation proceedings or that their company is anything other than solvent.
Yes, well, whenever there has been a judgment and stories of this kind emerge after the event, one is always cautious about the credibility of what's being said. But having said that, I do need to be satisfied as to the position, and I think you need to ascertain whatever you can to see if there's any truth in any of it. And the question really is, how long do you need to do that?
I'd estimate. Sorry, Your Honour.
No, you carry on. It's always the problem with these.
No, indeed.
This platform.
I'd estimate somewhere between 2 and 3 weeks, just to ensure that we can solicit the information from, verifiable information from the Kuwaiti courts. I mean, certainly after this hearing, what we would be doing is writing to the other side's lawyers and asking them to provide us with evidence within 24 hours of these supposed proceedings. If they've just been instructed and they've taken it upon themselves to write to the court and make this representation, I'm assuming they have verified these claims themselves. And I think subject to that, receiving that confirmation within 24 hours and the supporting documentation, we would then look to try and verify it to make sure that it's viable. My reason for asking for perhaps a 2-week period, I think 3 probably is too much, but a 2-week period is the documentation we receive will probably be in Arabic, and we'll want to just make sure that we can verify the content of it to Your Honour's satisfaction, and then revert with a statement accordingly.
Yes, well, I think the easiest thing will be then if I simply adjourn this hearing and you then make arrangements with the court for a date that works. So evidently, the lawyers who've written the letter here need to be notified of whatever date it is. And if there has to be an exchange of evidence about it all, that may impact upon what is a practical date. And I think, I'm afraid that's as far as I can take it today, realistically.
No,
that's what happens when you get these last-minute interventions.
No, absolutely. And hugely frustrating, but obviously completely understandable in terms of Your Honour's obligations. Can I propose the following then, that we'll liaise with the other side and subject to receiving their response within 24 hours, revert to the registrar with an update, a status update with respect to where we are. And then from there, we can then proceed to then schedule or pencil in a date accordingly.
Yes, if you keep the registry updated on what the position is, and they'll be in touch with me, and we'll fix a new date as and when seems appropriate. So there it is. Very good. Well, these things happen, as they say.
Indeed. Thank you very much for your time.
Nothing else you want to raise at this stage, Mr. Mackenzie?
Not at this stage, no. Although I probably, for the record, would want to reserve our position on costs.
Yes, of course.
Given the wasted costs today.
No, I understand that entirely, but we'll just have to wait and see how that works out too. Could I ask you to sign out so that I can have a quick word with the associate?
Yes, of course, certainly. I'll ask my team to do the same.
Yes, if everybody would sign out except myself and the associate, that would be very helpful. Thank you very much.
Thank you.